Hey everyone, and welcome to your mandatory yearly state update explainer. Today, we're building something a little different, your legal tool belt. Look, just like you wouldn't ever walk onto an active site without your trowel, your level, or your hard hat, you really shouldn't step onto a job without knowing exactly where you stand under California labor law. So we're going to break down the essential protections that keep you safe, secure, and respected while you're out there doing the heavy lifting. Now, whether you're a brand new hire stepping onto the site for the very first time, or a returning veteran who's been with Trencore plastering or Brix masonry for years, this protocol applies directly to you and your crew. The state of California mandates this update every single year because these laws, they're designed to protect every single worker in the plastering and masonry industries. Your work literally builds our communities, so it's absolutely our top priority to make sure you understand the framework that protects your livelihood. All right, let's dive right in. Here's the agenda for today. We'll be covering 1. Your California workplace rights, 2. Emergency contacts and safety, 3. Immigration and inspection protections, 4. Interacting with law enforcement, and finally, number 5, reporting retaliation and violations. Okay, starting off with Section 1, your California workplace rights. It is absolutely vital to understand that your right to a safe workplace, fair wages, and standard hours is protected no matter where you come from. Seriously, in California, if you are swinging a hammer, pouring concrete, or finishing plaster, the law applies to you equally, period. Your immigration status does not, and I mean does not, strip away your fundamental labor rights. So what does this actually look like in action? Well, when you're up on the scaffolding, reviewing plans with the foreman, or mixing mortar, you have strongly protected rights. You have the right to organize, you can join a union, and most importantly, you have the right to speak up about working conditions. If a piece of scaffolding looks sketchy, or if you aren't getting your mandated breaks, you are completely, legally protected when you raise those concerns with your coworkers or management. Moving on to Section 2, Emergency Contacts and Safety. Under California Labor Code Section 1555, you have the right, and listen, we highly encourage you to do this, to designate an emergency contact. Now, why does this matter so much? Because if the unexpected happens, and say you're detained or arrested while on the clock, your employer is legally bound to inform the emergency contact you designated. We want to make absolutely sure that if something happens to you on our site, your family or loved ones are not left in the dark. It keeps your family in the loop and provides a really vital safety net. So make sure your emergency contact info is up to date with HR today. And hey, if the unexpected is a physical injury while you're pouring, plastering, or hauling heavy masonry blocks, just know that workers' compensation is there for you. It guarantees medical care for your injury, and it actually helps replace a portion of your lost wages while you heal. Let's face it, our industry is incredibly physically demanding. If you get hurt, report it immediately. You have a right to recover without losing your livelihood. All right, Section 3, Immigration and Inspection Protections. See that number right there? 72. By law, if your employer receives a notice for an I-9 employment record inspection from an immigration agency, they cannot just keep it a secret. No way. They must post a notice for the entire crew within 72 hours. This ensures complete transparency on the job site, so you are never, ever caught off guard. And listen to this. It is completely illegal for any employer to use your immigration status as a weapon against you just for exercising your workplace rights. If you complain about unpaid wages or safety issues, an employer absolutely cannot retaliate by refusing your genuine ID documents, selectively running E-Verify on you but not the rest of the crew, or threatening to call immigration authorities. These are unlawful employer actions. California law strictly prohibits them to ensure you can work and speak freely without looking over your shoulder. Next up, Section 4, Interacting with Law Enforcement. Understanding the difference between public and non-public areas is a real game changer here. Agents can enter public areas freely, think of our parking lots or the front office waiting room, but they absolutely cannot enter restricted workspaces, like our active scaffolding zones, the mixing stations, or employee break rooms, without a specific judicial warrant. And remember, a standard administrative form, that is not a judicial warrant. It has to be signed by a judge. In fact, California law takes this a whole step further. It's not just about what the agents can do, it's about what the company must do. Without that judge-signed warrant, your employer is legally prohibited from just waving them in. We are legally required to refuse entry to those non-public zones. The site is restricted for a reason, right? Your workspace remains secure unless a judge specifically says otherwise. Now, what if you are directly approached by an officer or agent? Just remember these 3 vital steps to safely invoke your Fourth and Fifth Amendment rights without escalating the whole situation. First, ask, am I being detained or free to leave? If they say you're free to leave, you can just calmly walk away. Second, whatever happens, remain calm. Do not physically resist and never run. Third, if you are detained, you have the right to remain silent. Clearly state that you wish to remain silent and request an attorney. Don't provide false documents or lie. That's only going to escalate your legal trouble. Just use your right to stay quiet. Also, under the First Amendment, you have the right to observe and record law enforcement in public spaces. You can absolutely record these interactions on your phone, but, and this is a really big but, you must stay a safe distance away and never physically obstruct the officers. Verbal escalation or physically getting in the way can really put your safety at risk and even lead to criminal charges. So stand back, stay calm, and record if you feel the need to document the situation.
All right, our final section, number 5, reporting retaliation and violations.
We kind of touched on this earlier, but it definitely bears repeating. Retaliation is illegal. Whether you file a safety complaint because the scaffolding just isn't secure, or you participate in union activities, punishing you for that is strictly against the law. If an employer suddenly fires you, slashes your hours from 40 down to 10, or makes threats against you and your family right after you exercise your rights, well, that is illegal retaliation. Okay, I need everyone to grab your phones right now. Seriously, pull them out and take a picture of this. These are the direct lines to the government agencies built specifically to investigate violations and protect you. If it's a wage or retaliation issue, you call the labor commissioner. If the site is physically dangerous, that's Cal OSHA. Hurt on the job? Contact the DWC for workers' comp. These numbers are your direct lifeline to enforcing the rights we've just been talking about. Seriously, save them in your contacts right now. So you now know your protections, how to navigate inspections, and exactly who to call if retaliation happens. Your hard work builds the very foundations of California, but what are you doing today to ensure your legal foundation is just as strong? Equip your tool belts, share this knowledge with a coworker, and never step onto a job site unprotected. Are you ready to build with confidence?